The law around time limits to start court proceedings can be complex, and all individual circumstances should be discussed with a specialist solicitor as soon as possible to ensure that time limits are not missed. The time limits which apply to medical negligence claims can be different to time limits which apply to other claims. The court does have a discretion in some cases to allow claims brought as a consequence of negligent treatment to continue if started after the expiration of the limitation period. However, this is discretionary and should not be relied upon. In a medical negligence claim for an adult with cognitive capacity to give instructions, the claim should be started in the court by issuing a claim form within 3 years of the negligent mistake and the injury, or 3 years from which the claimant first became aware that something may have gone wrong, resulting in an injury if that is later. For children, the 3-year time limit period does not start until the child is 18 years old. For those without the cognitive capacity to give instructions in a litigation claim, the time period may never start to run, and so in theory, there may not be a time limit within which to start court proceedings. However, there are complex rules concerning those who had capacity at some point after the negligent mistake, even if capacity has subsequently been lost, as in general, time will start to run when the person has capacity and will not stop running when capacity is lost. Where the injured person dies within 3 years of the negligent treatment, there may be a further 3 years for the injured person's dependents or personal representatives to start a claim in court. We can't give specific legal advice on which you can rely on without having been formally instructed by you, and the best general advice we can give you is to discuss your individual circumstances with a medical negligence specialist as soon as possible.